Hello guys, welcome back to my channel. So today we're going to be talking about the word and the concept terms as used in contracts or in contract law. In the legal world, the concept terms define the obligations and the provisions of contracts or of documents that bind parties together. So terms portray the intent of the parties, the conditions that are involved in respect to that document or contract. So in essence, terms form the backbone of a contract or document, and the terms stipulate what each party is supposed to do or is supposed to refrain from doing. Now, from this definition of the concept of terms, the nature and importance of terms is that the terms stipulate what binds each party. And so terms represent the intentions of the parties and is the basis on which the enforceability of that document or contract rests. This means that by the nature of terms, if the terms of a document or a contract are unclear or uncertain, it could make the contract unenforceable or even void, and so you cannot enforce it against the party. So this is how important the terms of a contract or a document are. Now we'll look at the features of terms of a contract. First of all, the terms will define the subject matter of the contract. And by subject matter, this means the key purpose of the contract. The subject matter can be rent, because you want to do a lease, so it has to do with taking a lease and tenancy. So that's the subject matter of that contract. So the terms will define the subject matter of the contract. The second characteristics of terms is that terms define the obligations of each party to the contract or agreement. Now, this means that the terms will clearly define what each of the parties that will sign the document is supposed to do, what each party is obligated or expected to do. And note that with respect to obligations, usually all parties have an obligation. So we'll look at the examples that we have used earlier. And I used the example of a lease agreement, a tenancy agreement, or assignment of property or conveyance. The obligation of the seller is that the seller wants to sell the property in a deed of conveyance or assignment to the purchaser that is free from disturbance. So the seller will undertake that the property is selling doesn't have any bad title or any person that will come and make claims against the buyer. And so in that deed of assignment, typically you will see the covenant or the agreement of the seller that the seller is going to indemnify the buyer if there's any adverse claim. And that indemnity means that the seller is going to cover up for the buyer if there's any adverse claim against the buyer's interest. Terms of the contract will make clear all these obligations. You will know where this party's obligation starts and stops, and you know where the next party's obligation starts and stops. The third characteristics or features of terms is that the terms now provide for remedies for breaches of the obligations of the parties. I just noted now that each parties will have obligations and the terms will clarify the obligations of the parties. Now, the terms will now go further to provide remedies where any party has breached his own obligation. The fourth feature of terms is that the terms define the duration of the contract. So the terms will usually make that provision because no contract should last forever unless it's an outright sale. And in this case, the terms will also make you know that it is a full transfer that has been made, and so it's permanent. So basically, the terms will tell you the duration, whether it's an agreement that has a permanent nature, like a deed of conveyance or assignment, or whether it's an agreement that has a duration, maybe a 1-year term, a 6-month term, or 2-year term, or 3-year term. The terms will generally provide for the duration of the obligations of the parties. Finally, the terms of a contract provide for the conditions that govern the contract itself. So in this case, the terms will provide which laws govern the contract or which courts can have jurisdiction to entertain matters of dispute in that contract, or whether it will be referred to arbitration or whatever other form of dispute resolution mechanism that the parties want to go by. So the terms will provide all those conditions. But note that where the terms of the contract do not expressly provide for these conditions that will govern the contract. The terms and the nature of the contract will determine the applicable laws. This will take us to the subheading classification of terms. Under Nigerian law, terms are broadly classified under express and implied terms. As the name implies, express terms are terms that are categorically stated. They are provided for in the contract. Now, all these will matter if the matter goes to a dispute. The courts will usually interpret the express provisions of the contract as strictly as they are. If the supplier was supposed to supply 1,000 units of goods, but the supplier was not able to meet up with that agreement and the supplier supplied only 800, so you see that the supplier has breached his terms or his obligations as contained in the contract. So the courts usually interpret the contract based on the express provisions of the contract. Then the second broad classification of terms are the implied terms. And as the name implies, implied terms are terms that are not expressly stated but are inferred or assumed either by law or by custom. Or by custom here, we mean the custom of the trade environment of that business. Implied terms could also be inferred by the parties. But you can see here, it has to be taken very carefully because, yes, you can presume intentions of the parties based on the facts of the case. There's some assumptions and presumptions can be made, but they are very tricky. And that's why you see that express terms are the best. So because those express terms give no room for assumptions or presumptions or any kind of conjectures. The first factor that the courts will use to determine the terms of a contract is the language of the contract. And the language of the contract, it doesn't refer to English language or French language or all of those. The language of the contract here refers to the wordings that are used in the contract. So let's look at an example. There's an agreement here, and on this agreement, the bold title on the front cover says Deed of Assignment. However, when you now go into the wordings of the agreement, the actual wordings, the wordings of the agreement begin to sound like a tenancy and not like an outright purchase. So the court is not going to look at the heading or however you have couched it, but to go to read the meaning of the language of the document. So this means that the first thing to determine the terms of an agreement is the language of the agreement. And this is what the courts will use. The second factor is the surrounding circumstances that are involved in the contract. In the previous example that I've used, the court will look at the surrounding circumstances, that the general nature of the agreement speaks to a tenancy and not a purchase. The third factor that the courts will consider is the conduct of the parties. And by conduct, the courts will also look at what the parties have done based on the document that is before the court. That same example that we have used, if the court determines that one party has occupied the premises for a time frame and has paid some money to the other party for that specific time frame, the court will decipher and deduce from the conduct of the parties that is a tenancy agreement that has been created. The fourth factor is the applicable law that govern that document. So this strictly speaks for itself, that the laws that govern the document will be used to determine the terms. Like I've said earlier, if the contract was entered into by two parties resident in Nigeria and that are Nigerians, and the contract was to be performed in Nigeria, there's no external factor, then the laws that will govern this contract will determine the terms of that contract. Finally, the fifth factor that the courts will consider when determining the terms of a contract is the applicable trade and customs of that business environment. like I've also explained earlier, the nature of the business will determine the terms of the contract. So in this example that we have used up till now, the custom that is applicable to the tenancy domain will apply. So it is based on these factors that a court or a third party can determine the terms of a contract. There are a few key points to note. The first key point to note is that for implied terms would have to be read into the express terms of the contract. So where a third party or a court especially is trying to determine a dispute, the terms that are implied have to be implied and assumed or presumed into the express provisions that have been written down, the express terms of the contract. So the implied terms are not just to stand alone. The second key point to note is that for express terms, they ought to be clear and unambiguous. Recall that at the beginning of this video, I stated that if the terms are not clear or they're uncertain, they could make the entire contract void or unenforceable. The third and final key point that we'll be noting is that terms must comply with the law. Again, this is very important because where the terms of a contract contradict the laws, then the contract will be unenforceable. So terms of a contract must comply and not contradict any given law that will govern that contract generally, because this will affect the validity of the contract in entirety. In conclusion, it is important to note that the terms of a contract are the lifeblood or the lifeline of the contract. And so to avoid running into this kind of problems where the parties may not have any remedy because of unclear terms or because of terms that are against the law, it is always important to seek proper legal counsel, which we offer, to ensure that your contract can be enforceable and you can get your remedies or the value of your money in any business you enter into. I hope you got value for it. Kindly make your comments in the comment section if you have any, or you can ask questions for further clarifications and guidance. Also, please do well to like this video and subscribe to the channel so that you will get more updates when we post more videos on the channel. I'll see you in my next video. Thank you for staying. Bye.